This is for chapter 5, the contract law. So in this chapter, we're going to discuss the essential element of a contract, difference between void and voidable contract, identify and discuss typical misrepresentation encountered in real estate contracts, where we identify mistakes encountered in real estate contracts and explain the options available when the contract is breached and outline various ways in which an agreement may be terminated, discuss the power of attorney, and discuss regulatory requirements involving written agreement, offer to purchase, inducements, and inaccurate representation, as I written about 2002, and I'll also apply concept involving contract law to typical situations encountered by salesperson and brokerage. So let's begin with the contract essential. Uh, the, uh, the law of contract covers a large sector of law in general, and basic familiarity with the legal requirements of a contract is necessary. So a contract is a legally binding agreement between two or more capable persons for a consideration or value to do or not to do some lawful or generally intended act. In other words, the contract is a binding promise of one person made to another. It is more it is more than a mere offer to do something or a mere statement of intention, or requires meeting of minds of the parties, whereby a legal rather than a moral obligation is created, imposing an enforceable duty to fulfill the promise on one party and conferring the legal right on the other to claim its fulfillment. Very often, for a typical contract, there will be promises given by each party to the other, in which case the promises are said to be normal. In reality, the contract is an agreement between the parties, not the document on which it may be written. The document is only a piece of paper purporting to give evidence of a contract between the parties. If any of the elements essential to the contracting process are absent, it will matter very little how well the document has been prepared. So again, the required elements of the contracts are capacity of the parties, lawful object, consideration, mutual agreement, genuine intentions, and should be definite and clear. So to recap, the required elements are: the parties entering into the contract must be legally competent to enter into a contract, which is called as the capacity of the parties. The contractual agreement must be lawful object, or legality of the object. Each party must receive something, which is consideration. There must be an offer and acceptance, which is a mutual agreement. Both parties must consent to the terms of the contract, which is genuine intention, and the agreement must be certain, definite, and clear. A contract not fulfilling all all the requirements may be either void or voidable. A void is which never came into existence, voidable, originally valid but capable of being rejected by the offending parties at a later time, illegal, is not enforceable by the court. To recap, the contract can be either void, voidable, or illegal. So void is which assumes that it never came into existence. Voidable is originally valid but capable of being rejected by the offending parties at a later time, and illegal is not enforceable by the court. A contract that is void is said to be a nullity at law, with no force or legal effect. As far as law is concerned, the agreement does not exist. Neither party can enforce it, and neither party has any obligations under it. The question of void and voidable contract relates to a much larger issue concerning the avoidance of a contract. In other words, cases may arise when the elements of the valid contract are present. It's just not void, but where the promise of one or both parties have been given on the basis of or affected by some misunderstanding, false inducement, force, or the like. So the offending party has the right to redress. Usually, two types of redress for grievances of this kind are either to allow the avoidance of the contract altogether, or to obtain damages to the for the conduct of the other party. Such instances involve voidable contracts as opposed to void contracts that do not exist. So the case an example of void contract is, let's say, somebody, buyers and seller, contracted to buy a property, but then the property was disturbed by fire. Now, in this case, the all the elements of the contract are in existence, but the structure is not there. So the contract is impossible to perform, and would be judged as void. Avoidable is a contract that which is enforceable, valid, and binding until rendered void. A contract that is voidable is the one where the offending party may make a choice. The person may choose to avoid the contract and treat it as being at an end, or treat it as subsiding and enforce it against the offending party. The practitioners may encounter the issue of whatever contract in the case of minors. As a general statement, a minor, the age of majority will vary between provinces, cannot be liable for contract unless it can be said that the contract was for a necessity, being generally food, clothing, medical service, and lodging. Not only must the item be of a category recognized by the law as being a necessity, but it also must be necessary to that particular infant or minor at that particular time. The category of lodging would not likely to be extended by the court for the purchase of a house, since there are many alternatives way to obtain shelter. Contract entered into by the minor for the purpose of or sale of a land are voidable by minor. If the minor does nothing to void the contract within reasonable time after he or she reaches the age of majority, then the contract becomes binding. However, the minor may repudiate the contract upon reaching the age of majority by notifying the other contracting party. The minor cannot recover what he or she has paid during the minority on the amount of the contract, but the other contracting parties whose contract has been repudiated cannot compel performance of the balance of the contract following repudiation. In many instances, the matter of repudiation is finally resolved in the court because of the fact that the minor may be liable for their contracts, where such contracts were necessities. In making decision, courts will also look at such factors as the knowledge of the infant of his or her right under the law of contract, or whether the minor has acted in any way to indicate that he or she intends to carry out the obligation under the contract. However, the minor acts in any way to indicate that he or she intends to carry out his or her obligation under the contract, such as making payments after the age of majority, then the court will likely not allow the contract to be repudiated by the minor. It is a material that the minor may have held himself or herself to be over the age of majority. Even under such circumstances, the minor has the option of voiding the contract. Another important factor is that the adult representing the minor cannot approach the court to have the contract voided. Such a contract is binding until the minor brings the case to the court. If the adult represents the minor by co-signing the contract cannot be voided even by the minor. If a real estate salesperson suspects that a potential buyer is underage, it is advisable to request proof of age before proceeding. If in fact the potential buyer is underage, then the salesperson should advise the individual that a guardian or a trustee duly authorized must sign the contract on his behalf so that it can be legally enforceable. Contract entered into by others with limited capacity, such as a mentally incompetent person or intoxicated person, may also be voidable. The issue of why the voidable contract was is pretty involved. Capacity of the parties. The parties to the contract must, at the time when the contract is made, have the legal capacity to make the contract. Persons. When a contractual promises are enforced against anyone having legal authority, some persons are deemed to allow as either incapable of contracting or having only limited capacity to contract. In cases involving a limited capacity, the contract is considered voidable. That is, the contract is invalid until the individual goes to the court to void it. As long as a person of limited capacity allows the contract to exist, it may not be voided. Some examples of those with limited capacity to enter a contract include minors, mentally intoxicated person, or persons incapable of understanding the nature of contract by virtue of excessive use of drugs or chemicals, and or ill traits. To recap, some of the people with limited capacity to enter the contract include the minors, mentally incompetent persons, intoxicated persons, or illiterates. Minor. A person under the age of illegal competence is a minor. Simply put, all contracts with the infant for the sale or purchase of land are generally voidable, sometimes void, and not usually considered valid and binding on the minor. In the case of a voidable contract, the minor would be entitled to avoid the contract at any age, at any time until a reasonable time after the age of majority. However, if the contract is ratified After majority, the right to avoid it generally disappears. Avoidance is a privilege of the minor, and the other side is bound until the minor repudiates the contract. The age of legal competence was traditionally 24 and 21 years of age, but in Ontario it's now 18 years. Illiterate. Illiterate is defined as unable to read or write. In terms of a contract, the question about a literate person and whether the contract is binding rests on whether the person knew what was being signed. An infant is defined as a person who is minor under the age of legal competence and thus incapable of independent judgment necessary to undertake a legal obligation. Practitioners should be particularly sensitive to situations involving potential minors transacting real estate or real property. Capacity of the parties beyond persons. The capacity of the parties extend beyond persons, and the following is provided for description purpose only. Corporation usually has the right, power, or privilege to enter into a contract concerning the purchase or sale of real property, unless specific restrictions are located in the article of corporation, or the corporation has not enacted empowering provisions in its bylaws. Two important conditions are required concerning corporation involving the acquisition or disposition of real estate. First, does the corporation exist? And secondly, does it have the right to enter into such contracts? Partnership normally provides under provincial legislation that any partner may bind the other partner in a transaction during the ordinary course of business. Condominium or cooperatives permitted to enter into a contract for the purchase of and sale of real property in line with the incorporation document and or statutory regulation limiting the scope of such organizations. Non-profit organizations have the right, power, and privilege to enter into a contract for the purchase or sale of real property. For example, incorporation document for real estate board often specifically mention the right to acquire or dispose of a real property. Lawful object. If the object of the contract is illegal by statute or contract law, the contract will be void and unenforceable in the court. For example, a contract would not be considered lawful if the acquisition involved criminal activity or was a direct violation of the competition policy or deliberate evasion of taxes. In such instances, the contract will be totally void. Examples of illegality to or no lawful object would include contracts contrary to the public policy or good morals, injurious to the prejudicial or to the safety of the state or to the public service, tending to pervert justice or to abuse the legal process, in restraint of the trade such as price fixing, in restraint of the personal liberty or marriage, and for the commission of criminal offence or civil wrongdoing relating to the gambling or wagering. So the object of the contract is an important criteria. If so, and if the object of the contract is illegal by statute or by the common law, the contract will be void and unenforceable in the court of law. So the examples of illegality or no lawful object would include contract which are contrary to the public policy or moral contract, injurious or prejudicial to the safety of the state or to the public service, ability to pervert justice or to abuse the legal process, in restraint of the trade such as price fixing, in restraint of personal liberty or marriage, and for the communication of criminal offence or civil wrong or relating to the gambling or wagering. Often buyers and sellers believe that the sale made on Sunday is illegal or void. The Supreme Court of Canada has that particular section of Law Day Acts relating to this issue was unconstitutional in the view of Canadian Charter of Rights and Freedom. The object is a real estate transaction. The object in real estate transaction is the transmittal of ownership of the seller's property to the buyer. If the object is illegal, according to the statutory provisions of the common law, then the entire contract will be void and unenforceable. Consideration. Consideration is what each party receives or is to receive in exchange for promises to act in a certain manner and is sometimes and it's something that is given as a promise or to a promiser to make the promise binding. The sense of a valid binding contract is the idea of a bargain between the parties. The bargain is a consideration of a contract or may consist of an act intended for an act, a promise intended for a promise, an act intended for a promise. As a result, each side reserves something for the other from the other. In the real estate transaction, consideration usually takes the form of a promise from the seller to sell in return for a sum of money to be received by the buyer. Consideration is best used in terms of following four headings: value, lawful, past consideration, seal. Value: what either party receives must have some value. What each party receives must have some value. Interestingly, that the court does not access the adequacy of this value, but only its existence. Sometimes the practitioner understand the concept of valuable consideration. This does not mean that the consideration gives some extraordinary worth associated with it. The courts are only interested that it exists. Of course, if the consideration was so minimal as to make the contract one-sided, the court might act based on consignability of the agreement. Further, the court might review the adequacy of the consideration if the undue influence, fraud, duress, or representation exist. Lawful. The best the best explanation is by example. The buyer and seller knowingly agree to transact business based on the stolen money or goods. The contract does not have a lawful consideration. Past consideration. Um, Old consideration is a no consideration. For example, a buyer of a cottage enters into a cottage on subsequent agreement. The seller mentioned that he will include the boat. No documentation is prepared and no consideration is given. At the closing, the boat was removed by the seller. As consideration did not exist and the past consideration of $1,000 did not include the boat, the buyer does not have any enforceable contract concerning the boat. Seal. A contract can be made binding without the consideration if a seal is used. When the promise is made under seal, no consideration is required, since the law presumes the act of sealing replaces consideration. Therefore, it therefore in the case of an agreement or a contract, if the legal seals are fixed at the time of signing, no consideration is required. This is only valid if the parties are aware of the legal effect that a seal has on the contract. The ancient method of sealing by wax or swearing a solemn oath has been replaced with the modern legal practice of a variety of methods to indicate the document has been signed under seal. Generally, the court will only accept anything from red wafers to pre-printed or handwritten seal as long as it is clear that the parties signing knew or were directly to the fact that they're signing under seal. Although the legal sign of the corporation does not perform the same function, valuable consideration is still required unless legal seals are also present. So while in many instances the corporate seal is unnecessary for signing documents, any document signed on the behalf of the company under the corporate seal and indicating the authority of the person signing by inserting the person position above the signature would be a good business practice. The act of placing a mark or a symbol on the document is evidence and assurance of intent to carry out the promises contained therein. A sealed document provides added confirmation of the intent of the parties to perform the agreement. Under the old conventional law, the official seal was often used as a substitute for consideration. Where a promise is made under seal, no consideration is required, since the law presumes that the solemn act of sealing replaces consideration. If a promise is not made under the seal, consideration necessary to make it binding must be of some value, but the need not be equal to what is received in return. Must move from the promiser to the promiser. Must be lawful. The promisee cannot rely on the past conduct of promises as a consideration, valuable consideration. If the person promises to do consideration, the law will not enforce that promise unless something is received or promised as an exchange. Whatever is given or is to be given is referred to as a valuable consideration, and therefore anything to do anything to which a value can be attached, given given by the promises to the promiser, and may be an act written for an act, a promise written for a promise, an act written for a promise. Mutual agreement, offer and acceptance. The contract is formed when the offer is made by is accepted by the other party. The following items are general rules. The offer must be complete and definite in terms, must be made by one person or a personal corporation, or a public at large, must remain open for the acceptance for a reasonable period of time, may be revoked or withdrawn prior to its acceptance, must be communicated to the offeree. The acceptance of the offer is based on the four requirements: unconditional, communicated to the offerer, made in the manner required by the offer, and made within the time period required by the offer. Genuine intention. The agreement must be genuine and give out more of an outward appearance of a contract. In other words, one of the parties may have induced to enter into a contract by improper means, and the document does not express what was intended. Inducement by improper means are caused by four different circumstances: mistake. Mistakes can be common, mutual, or unilateral. Misrepresentation can be innocent, negligent, or wrong, and also fraudulent. Duress or undue influence, and failure to disclose. So to repeat, the genuine intentions are required. The inducement by improper means can be caused by four different situations. It can be mistake, misrepresentation, duress or undue influence, and failure to disclose. A mistake can be a common mistake, mutual mistake, or a unilateral mistake. A common mistake is a mistake in which both parties make the same mistake, that is, each is mistaken about some underlying fundamental fact. A mutual mistake is in which the parties misunderstand each other and cross purposes. Unilateral mistake is when one of the parties is mistaken concerning a fundamental character of the contract. Misrepresentation is a false statement or assertion made by one party to the other before or at the time of contract with regards to an existing fact. Duress and undue influences. Duress occurs when the person does not act within their free will, but insists to the fear of person suffering. Undue influences is the improper use of a person's power over another to induce the person to the contract. Following are selected examples: one party is knowledgeable and experienced, but the other party is ill informed and inexperienced. A gift is made by the child to the adult, guardian or ward. A beneficiary to the treasurer, a patient to the doctor, a person a person to a spiritual advisor, a client to the solicitor. A real estate person purchases property from his or her client. The person appearing to have exerted undue influence must prove that the transaction was reasonable and fair, and that no advantage was gained due to his opposition. The fact that the person claiming undue influence received independent legal advice or valuation of a property is valid to establish that a reasonable transaction occurred. Failure to disclose. Non-disclosure of the latent defects might invalidate a contract. Definite and clear. The terms in agreement must be definite and clear, and if the essential term have been agreed upon, the binding contract does not exist. However, this doesn't mean that the term have been decided. A term of the contract can be established through arbitration by the third party. Misrepresentation. So a misrepresentation may be defined as a statement or assertion made by the one party to the other before or at the time of the contract regarding some existing fact, matter, or circumstances affecting the contract or its object. So it can be an innocent misrepresentation where one party or the material fact, so where there's a statement by one party or the material fact that is untrue but is honestly believed to be true. For example, if somebody asks which school is serving in area, and the response was the response by the seller based on asking a neighbor was K-8, and later found to be something else, then yeah, that would be considered as an innocent misrepresentation. A fraudulent misrepresentation has three elements. The representation must have been made with the knowledge of its falsity and with reckless disregard to the truth. The purpose must have been to induce the other person to enter into a contract, and the representation must have been acted onto the other party's prejudice. And there is a negligent misrepresentation in which if the special relationship exists between the parties and the representation is made misrepresentation is made negligently, then the person who is misled has the action for damages. When it's clear that the statement was made with intention that it can be relied on, and that the person did rely on it, then the claim for damages may arise. A mistake can be common, mutual, and unilateral mistake. In case of a mistakenly signed document, in which they were signing of a contract that is fundamentally different from what was being contemplated, as a general guidelines for real estate practitioner, when a person is induced into the fraud as a person by signing a document, which is listing agreement, the person may successfully plead the document is not valid. Non el festum is essentially literally means it's not his deed. This simply relates to the legal rule that a person who was induced innocently or fraudulently by another person to sign out a document that's fundamentally different from what he was contemplated, then he is not bound by that document. Now, in terms of contract documents, there is an interpretation and the privity. When the dispute arises as to the contract meaning or the right behind it, the court will apply varied legal rules of evidence and interpretation to discover what the parties to the contract intended. One important rule is a parallel evidence rule, in which provides that a completed written contract can only be altered, varied, amended, except when writing, and may not be explained or added to by any verbal evidence, agreement, or evidence as to the intention of the parties. Privity is a general rule in that only parties to the contract can enforce it or be bound by it. Now, in terms of a breach, there so essentially a breach is a failure to fulfill an obligation under a contract. The breach of a contract by another party results in the imposition of a new obligation in place of the broken one by conferring the right of legal action on the party injured by the breach. A breach may discharge the injured party from the other obligation as to perform his or her side of the bargain. Breach may occur because through the express refusal to perform the contract, making it impossible to perform through one's own action, or through the failure to perform. The remedies, rescission. A rescission set aside the contract by a request that the court to set aside the contract because the builder has encountered financial difficulties, has only begun renovation work, and is apparently unable to complete the work. Damages represent the compensation for losses incurred. Quantum merit. Quantum merit is the court determination of a reasonable sum of money for the work or services already performed. Specific performance is the court decree in which, or the order that a party in breach must do specific things that have been promised. This is a discretionary remedy and not an absolute right. It will be rewarded only when damages are not adequately damages are not adequate remedy, and the contract is fair and just, and the injured party acts promptly and fairly in claiming its right to a specific performance. Injunction. When a broken promise was to refrain from doing something, the court may award an injunction to refrain from offending parties from doing that act. Termination discharge. Termination of discharge of the contract can be done by mutual release, by mutual agreement, by performance, by impossibility of performance, by operation of law, and by the breach itself. A mutual release is essentially the term referring to the mutual release by the form signed by the appropriate parties, acknowledging that the agreement no longer binds them, and null and void is described as having no legal force or effect. Nine times the power of attorney. A power of attorney is a delegated authority granted to a person to act legally on the behalf of the other, including signing of a document. More specifically, the power of attorney is an instrument in writing whereby one person appoints another person is his attorney and confers upon the attorney authority to perform the specified act or a kind of acts on the behalf of the donor. The donor is a person who grants the power of attorney, and the attorney is a person who exercises the power of attorney. Practitioners may encounter power of attorney in signing various documents, the listing an agreement of purchase and sale. Ontario recognizes three types of written authorization. One is the attorney, power of attorney for personal care, a continuing power of attorney, and a continuing power of attorney for property, and a power of attorney. So a personal power of attorney for personal care is pursuant to the Substitute Decision Act concerning the medical or care decision. A continuing power of attorney for property is also under the Substitute Decision Act. This power This power of attorney continues in force even during the subsequent donor in incapacity. And the power of attorney, this is older form of power of attorney, was most commonly used prior to the enablement of Substitution Act. This form deals with the property and other matters, but is infrequently used as it does not continue in force during a subsequent donor incapacity. So to recap, a power of attorney for personal care is for medical care decisions. Contain power of attorney for property is a power of attorney which continues in force even after the subsequent donor incapacity. And the older power of attorney is not used so well because is not used currently because the form it d- does not continue in force during the subsequent donor incapacity. The real property. The power of attorney are of general nature but can be given for a specific purpose and time dealing with a particular property. The continuing power of attorney for property is commonly used given its continuance despite the donor subsequent donor incapacity. Statutory powers govern the giving of such power, effective date, limitations, revocations, which may act as who may act as attorney, obligations of attorney, and other significant legal issues. A continuing power of attorney for property dealing with real estate must be registered in the registry office showing both the donor and the attorney. Any document that is signed by the attorney on the behalf of the donor should be in the donor's name. When the attorney signs the document pursuant to the power of attorney, that the document should state that the donor was of age when the power of attorney was signed and the power of attorney is in effect. So essentially, so let's say Susan Smith has been appointed as a power attorney for William Smith to Sir William Smith. How the listing agreement for purchase of purchase and sale deed and supporting documentation shows William Smith as a seller. Document will be signed by Susan Smith as follows. Susan Smith as attorney for William Smith. This document would also contain the recital that containing power of attorney for the property registered June 1, 2006 as instrument number this. To the best of our knowledge and belief, the containing power of attorney is still in full force and effect, and principal was at least 18 years of age when it was executed. So to recap, a containing power of attorney dealing with real estate must be registered in the registry office showing both the donor and the attorney. Any any document that is signed by the attorney on the behalf of the donor should be in the donor's name. When the attorney signs the document pursuant to the power of attorney, the document should state that the donor was of age. The power of attorney was signed and the power of attorney is in effect. And an attorney can only sign for the donor who granted the power of attorney. The attorney cannot sign document for the party such as the donor's spouse or donor's co-owner. Separate power of attorney for these persons should be necessary. Now, in terms of Reba 2002, we need to look at what constitutes inducement, offer to purchase, written agreement, and accurate representation. The registrant must not, as an inducement to purchase, lease, or exchange real estate, make any representation or promise that the registrant or another party will sell, lease, or exchange the real estate. However, this provision does not apply if the registrant has entered into a contract with a person to whom the promise was made that obligates the registrant to comply with that promise. When the registrant is acting on the behalf of a buyer, only written offers may be presented for a written offer to be valid. The offer must be signed. The registrant cannot indicate that the offer has been received unless it is writing. The seller brokerage must comply with the comply with must retain the copy of the written offer it receives from the buyer, including any counter offer and any successful offer. The brokerage may retain an equivalent summary document for each offer rather than retaining a copy of the offer in its entirety. The seller brokerage receives the offer on behalf of the seller. The offer is made through the brokerage on the behalf of the buyer. The offer is not valid, not valid in transaction, and the summary contains all required information. The offer retention period provision in the Act enables the registrar to determine the number of offers received by the seller brokerage for the property in the event that the registrar receives a request from the buyer who made the written offer on the property, or the registrant acting on behalf of such a buyer. When requested by the registrar, the seller brokerage will must provide a registrar with a copy of every written offer received for the property and equivalent summary document as applicable. The copy of written agreements. This provision encompasses any written agreement between two or more parties, including buyer and seller representation agreement, service contract agreement, notices stated to such agreement. So essentially, copies of the written agreement must be given to to the person as soon as they are signed. And in case of the retention of offers, if the offer was not successful, then the copies or summary can be kept for 1 year. But if in case the offer was successful, then the offer must be kept in entirety for at least 6 years. Conveying offer. The fundamental obligation centers on offer being presented at the earliest practicable opportunity to the client. The ethical obligation also requires the availability of both of another registrant should the broker or salesperson be unavailable. This provision further requires that the delivery of the offer, regardless of who makes the offer, the content of the offer, the commission arrangement, and to any relating documents, a waiver of conditions. Written and legible agreement. Section 27 requires that agreement to be in writing. It also acts that such agreement should be legible. Additionally, this section applies both to the client and the customer who has agreement with the brokerage that involves providing services in relation to the agreement involving the conveyance of interest in real estate. Copies of the agreement. This provision applies to both client and the customer. While this obligation does not specifically state that the license should also forward a copy of an agreement to the lawyer for the respective client, and this custom practice is assumed. Delivery of deposits. Except as otherwise provided by the law, if the registrant is presenting an offer or providing service to the customer in connection with the trade of real estate, must there the deposit document in accordance with the agreement. Inaccurate presentation. This requirement regarding inaccurate representation provides that the registrant must not make incorrect statements regarding either a trade in real estate or service provided by the registrant. Fraud, error, or misrepresentation. This provision not only requires the registrant avoid fraud, error, or misrepresentation, but must also take steps to prevent it. I think with this we're done with chapter 5. Thanks.